answer interrogatories and for them to produce certain documents. The chairperson particularly had said that she'd be available for cross-examination. Now, the petitioner's point was that under the specific rule, Order 36, the insipid arguments by the respondents. Nevertheless, the courts have ruled in favor of the respondents, saying that they do not agree with us, that even though this is the EC, a constitutional body, the same principles that are applicable to ordinary people should be applicable to the Electoral Commission, and therefore they were upholding their request not to mount the witness box. Subsequently, also heard Mr. Chikata. He said, well, if that is the decision of the court, then he's going to apply. In fact, he's in the process of filing an application for us to reopen our case and to subpoena the chairperson of the Electoral Commission. And so that is the status now. So now, for us, those are important, there are important lessons to be learned from this. Now we have an EC who, when a request for information was served on them in the past, they refused to respond. We have an EC who was requested to answer interrogatories. They refused to respond. We have an EC that was served with an application or a notice to admit facts. They refused. We have an EC that was asked to produce documents relating to the election. They also refused that. That's the kind of EC we are dealing with. I mean, where are the principles of accountability? When is this EC going to be accountable? Any questions?
Yes, ma'am.
Counsel for Petitioner also announced that he will also file an application for review of petition of the court. So that's two applications he will be filing.
I'm sorry, review of the decision we had today.
Today's decision.
Okay.
He will apply for a review of that decision.
Okay, so maybe that even gives me the opportunity to ask this question. You have described as
a decision, and so we are going to file an application for review.
Madam, now that the court has set the 13th for all parties to submit their addresses, now that the court has set the 13th for all parties, 15th for all parties to
okay.
You file by 17th, and you have
a case strong enough to warrant them presenting witnesses in the box. If that's not the case, I would like a response from you. As what you understood.
As simple. If we disagree.
Well, that's because then my question then would have been.
You heard
yes.
counsel for the petitioner on Monday, and we disagree with that position, that the evidence that has been given points simply to the fact that that declaration of 9th December is null and void. None of the two candidates got more than 50% of the valid votes.
And
only one declaration, 9th December declaration.
So the petitioner...
There were purported corrections. Have you seen any Gazette notification dated on any of the...
Okay, the petitioner's case, why not just allow the court to rule on your case so far, since the respondents are withdrawing from...
That there are questions that we put to her that only she can answer. Nobody else can answer. irrespective of what case we have put before the court, there are questions in relation to this case that she alone must answer.
All right. You keep saying that you are depending on, you're not depending on the witnesses of the respondent.
We are not what?
And that you have your own special case. Can you tell us the exact case you are standing on to deal with this petition?
Have you seen the reliefs have you read the reliefs?
Yes, I am saying that you just said that you are not basing, or you are not even expecting the witnesses to make your case.
I answered the question that there are specific questions that she has to answer. It's as simple as that.
Let's do some 5 minutes. Yo, anyone? I say, and your bar court as Citrano. As someone at the court, a nimpa or say, Ubua, and say, a year managing Mensa, or dinner on my electoral commission. Or say, Oba Adakanum Babi Nanuana. Munim say, Nano Juada, Yama, a lawyer for you now, Kwame Obia Kanasem. Namuina Smutie in Samoa. A year, Lawyer Chachuchikata, Ujina Homa, a year petition, or the 2 judge our court. A weird chino, a canina bomwana, ye bayano, near court to a catcher and say, or ne young and nabbing say, Mameno, Ababa, Abetina, Adakanum. Na, a dear woman say, in some Misedi wa, Yabia Tuja, a D kind, ye, Yabisa Yano. Onwa asamo de beto kote numa wedi si atachire or say ye back cross examination obeya no ya samba ye inspection ye ko nkrata bim or see ye back cross examination obeya no na se ye du se brabetna de kanum bisa wa o se memma menko adakanum nanso court enyebua se onu de onu wo I say, my meno monko adakanum. Enti ama ye lawyer penny, and so they are 2 court names and your omukayano, 1 woman yard. As a pinano, you got a subpoena. Ya makota sheno. Say omadakanum. Not in someone also yan, says on no quantity returning officer or Ghana. In such a bizarre no be intimiano or no the mensa no bit me yano. Enti Obama court asheno. Every subpoena atwano. Aqua question some rather canoe, no be in some nano. And to wait in some menua, your lawyer for the 2 court in him. Sir, ye the omu mameno babadacum, Adacanade. Ye Gusujina baby, some mameno, so chow no pano, I was some mameno, or babajina decam. So near Bonibia, not some for Bibia in Syria, Adacanade, you begin to say, Omra. Imagine that can into baby Edina and in some you know today. And with the chance and MPB for Zaba, MPB for so almost one number, and also some ba. Now we be a second general coin. Here him some Macmenu Suba. Bam say Macmenu Elchin and Nancy, but we go see and say, there in some you know to court name. 2 applications. Ya the Baba court name na me ya duma ya se bie ensem no so. Na ya frɛ ma me no na be na de kanim. Madam wase.
Thank you, Papa.
It's not for me.
Your mama.
The general.
Put out today. First is that the law is settled, that a party cannot be compelled to adduce evidence under the circumstances that we are discussing. The law is settled on that matter. And you notice that the Supreme Court spent some time to educate all of us who are interested in the legal profession or are following this case on the various cases in times past when the courts have ruled, sometimes up to the Supreme Court, that that is the position of the law. Nyamiche versus Ansa, Bamo and Labi, and another, AMA and Hydrofoam Estates Society of Lawyers, they went at length to remind all of us that on several occasions, the courts have had to lay down this rule, that the law is settled. So if anybody comes with some new arguments as though it is a gray area of the law and not necessarily on the weakness of the defendant's case. A case is won on the strength of the plaintiff's case and not necessarily